This honorable court is now in session. Please be seated.
Welcome to our afternoon session. We're ready to go to work. Just call the first case, please, Mr. Hivner.
State of Tennessee versus Corey Forrest.
Thank you, Mr. Chief Justice, and may it please the court. My name is Brandon White of the Murray County Bar, and I represent Mr. Forrest. I would like to reserve 5 minutes for rebuttal in this case. As an initial matter, this case concerns the permissible scope of law enforcement activity or of activity for a law enforcement officer acting as a private citizen under TCA 47109. 47109 provides that a private citizen has the authority to conduct a citizen's arrest. And subsection A1 of that particular statute provides that a private citizen may arrest another person for a public offense committed in the arresting officer's presence. So, of course, in this case, Officer Barber, who was a member of the City of Columbia's police department, was well outside of his 1 mile jurisdiction outside of the City of Columbia at the time that he followed Mr. Forrest all the way down to the Murray County, Lawrence County line. And so at the time that he initiated the traffic stop of Mr. Forrest, at best he was operating as a private citizen. And I guess as an initial matter, I'm not disputing, because I don't think the standard of review would let me dispute, that Officer Barber, as a private citizen, had the authority to initiate the traffic stop of Mr. Forrest's vehicle for the offense of speeding. And so I think that he, based on the standard of review, that he did have probable cause to initiate the traffic stop. And I'll also note, before we get too deep into the weeds, that there are cases that indicate that a private citizen can effectuate an arrest for the offense of speeding. We look at some of the cases cited in the briefs: Bellamy, Johnson. There's also, the third one escapes me. There's a third one that's routinely cited that this can be done. And both parties take a good amount of time briefing the issue of, well, if you're going to pull someone over as a private citizen for the offense of speeding, what duties do you owe the arrestee statutorily?
First of all, did he have authority to blue light? He was able to stop him because he used a blue light. What authority did he have to use a blue light?
Well, he had no authority to use the blue light. That was illegal. A private citizen doesn't have the authority to conduct or to use emergency lights at all.
So what do we make of that? He acted illegally in stopping him.
And even stopping him. So I think that the standard of review, I don't think lets me argue that he wasn't speeding. But then the question is, well, can you even illegally pull someone over with emergency blue lights? I didn't stumble upon a case that it specifically addresses whether or not that stops the analysis right there. But it, as indicated in at least one of my briefs that I submitted, that is illegal. And cannot be done.
But where would we draw the line there? I mean, if we were to say that an officer is kind of limited when acting under the citizen's arrest statute to only things that a private citizen could do, I mean, does that mean that if an officer is in uniform, that he or she would be prohibited from making the stop? Because wouldn't even the very wearing of a uniform carry with it some authority that a private citizen would not have?
Your Honor, I don't believe so under the case law. I think, at least as far as some of the cases I've indicated, there have been officers who unquestionably arrested someone else outside of their respective jurisdiction. It's my understanding, according to those cases, that they were wearing uniform. And
so where's the line then? So they can wear a uniform, but they can't use blue lights. I mean, what if we're to draw a distinction, it needs to be one that's coherent. And where we can, figure out what falls on one side or the other. So what do you have a proposal for what workable line could be drawn?
All I can say with respect to that, because I think this is an exceedingly novel issue, because there's not very many cases that addressed this issue. All I can really say to that question is the Tennessee General Assembly has at least answered it relative to the blue light situation. That has been answered. The other parts of it, I could have an opinion, but I don't think my opinion necessarily carries much weight.
Well, I mean, it's not illegal to wear a police uniform, is it?
I don't believe it is.
I've
I think
never
it would be
heard of that.
illegal to act as a sworn
Impersonate.
police officer and not actually be a sworn police officer.
Right.
That's probably actually a violation of federal law.
But the case law doesn't distinguish between the police officer and the private citizen when they're talking about what a private citizen can do under statute, correct?
At least relative to the baseline foundation of what a private citizen can do,
Right.
that is
That's
correct.
yeah. And if he's acting as a private citizen, why would he have the right to do anything more than a private citizen does?
And that is my argument. And that would extend, Your Honor, to the blue light issue. I'll use myself a lot as an example, hopefully during this oral argument. I'm not a sworn police officer. I don't have the ability to go around in in this case, a marked police car with emergency blue lights at the top and pull people over.
And one of the, oh, sorry, go ahead.
Could a sworn police officer do everything that this officer did while obviously not in his jurisdiction? That if he had been within his jurisdiction, let's say he's not an officer of Columbia, but he's a state trooper. Did he do anything to violate the law if he had been a sworn police officer pulling this defendant over?
Your Honor, I think that presents, it's a very good question, but I don't think that particular analogy, even if I were to say yes to that.
Well, your argument is, I think, that you're making is that a police officer could have done this, but not a private citizen. And the Court of Criminal Appeals, I think you're trying to allude, that's where they went wrong. They analyzed this case just like if this had been a police officer on duty, right?
If this had been Trooper Kilpatrick from the get-go, if you will, who has jurisdiction statewide, I think that Mr. Forrest's arguments in this case would not float very well.
So when the Court of Criminal Appeals on page 4 say, they set forth there, why this was basically a legal stop and proceeding here. Say that the residence from which the defendant had come was a known drug trafficking residence. The amount of cash and lower denominations in his wallet. He had frequented the suspected residence over the course of a 2-day surveillance period. The subsequent traffic increase after he came and went. He lied to the officers about where he'd been before the traffic stop. I mean, all that's relevant when you're talking about a police officer, but maybe not a private citizen.
I agree with you, Your Honor, that it is not relevant to a private citizen. A private citizen is limited to not reasonable suspicion on whether all of those things add up to being able to do a dog sniff as the state submits later on in the course of the traffic stop, but does the private citizen have probable cause to believe that the person has committed the offense for which he's being arrested?
So you've conceded that the actual stop for speeding was okay.
Well, at least as far as he had probable cause to believe that he was speeding. But as far as Justice Lee mentions, the flashing of the blue lights, he had no statutory authority to flash his blue lights. In fact, that was illegal.
What was he arresting the defendant here for?
Well, he wasn't actually arrested. That's the whole problem with this, Your Honor.
Well, that's the reason I asked the question.
He purports that he's, quote, arresting the defendant for the offense of speeding, but he admits in the suppression hearing in this case that he never had any intention of actually completing the, quote, unquote, mission of arresting him for the offense of speeding. And that leads me into...
And that's something he legally couldn't even do. He couldn't arrest him for speeding.
I don't believe that he could, Your Honor. And there's some statutory conflict, at least as far as I can tell, in trying to read all these statutes together. We look at 47-113A concerning a private citizen and the disposition of the arrest, and that the private citizen shall, without unnecessary delay, take the arrested person before a magistrate. You try to read that in pari materia to something like 55-10-207, and that contemplates a law enforcement officer acting, and that statute says that if it's one of those offenses in Title 55, Chapters 8, 9, 10, or 50 that's not enumerated in subsection H, that you have to issue a citation in lieu of arrest and continued custody. And then you read that in coordination with TCA 47-118 that similarly states that for an offense such as this, you literally cannot arrest someone for the offense of speeding.
Well, arrest is defined broadly, though, isn't it, in the sense of detaining someone or something. That's not necessarily putting handcuffs on them and taking them into custody.
Or seizing them.
Yes. So in this instance, isn't it possible that a private citizen could stop someone from speeding, but then the private citizen would then have to rely on an authorized law enforcement officer to issue the citation?
I agree with that. They have to do something.
Yeah.
I think what that something is, as far as the statutory trying to meld all of this together, is a little bit unclear, at least to me, as far as whether they can literally arrest them and take them to the magistrate or to another officer.
I need to ask you about the remedy you are seeking. You are seeking to suppress this under the exclusionary rule,
That is correct, Your Honor.
but you're saying that he was acting entirely as a private citizen. If you had had somebody who was not a police officer who stopped someone, and let's say they did it somehow in contravention of the statute governing citizens' arrest, how do we apply the exclusionary rule to the actions of a private citizen?
I would agree that ordinarily a private citizen who is not acting as a government official or in concert with a government official, the Fourth Amendment does not apply. But there is case law that makes it very well settled that when a search or seizure is effected by a private citizen or private individual, and that private citizen is acting as an agent of the government or with the participation or knowledge of a government official, then the exclusionary rule takes effect.
Let me follow up on that then. With regard to the trooper showing up with the drug dog, what does the record reflect as to whom contacted the trooper to arrange for him to show up there?
It's my understanding from the record that it was known from the very get-go when Mr. Forrest left this apartment complex or this residence where this
Well, I
activity.
guess more specifically, my question is, did Officer Barber contact the trooper?
Your Honor, I'm not sure if it was Officer Barber or one of his colleagues, but either him or one of his colleagues had, and maybe it was even dispatch, who advised that we're sending Trooper Kilpatrick.
Does the record indicate that Officer Barber was aware that the trooper was coming?
Yes, Your Honor, because at I believe at approximately 10:19, which was roughly 2 to 3 minutes after the traffic stop had occurred, Officer Barber returned to his vehicle, and this is prior to Trooper Kilpatrick arriving, of course, and either one of his local, I guess it was dispatch, it's hard to exactly piece it together with this, but someone advised THP will be there in 5. So he was very much well aware that THP was en route, and it's my understanding from the record that he knew that before he even initiated the traffic stop.
So we would have to find that Officer Barber, is that his name? Am I blanking on it? Was the agent of what, Trooper Kilpatrick? Or?
I think that Officer Barber was the agent of a multitude of different people. He was the agent of Sergeant Adams. He was the agent of Trooper Kilpatrick. He was working in concert with
We would have to
dispatch.
find that he was the agent of a law enforcement agency with jurisdiction, right?
I don't know that the court necessarily has to conclude that he was an agent of the city of Columbia or the Tennessee Highway
I mean,
Patrol.
jurisdiction over where the area where the actual speeding stop was made.
I would submit that it is enough for the court that he was acting in concert with another government official, and so
Even if they're back in Columbia where there was no jurisdiction.
or it could be Trooper Kilpatrick. He was certainly acting in concert with Trooper Kilpatrick.
I'm just trying to drill down on what findings have to be, what the record has to support in order to apply the exclusionary rule.
And I think the problem as far as findings by both the Court of Criminal Appeals and by both the trial court, but particularly the Court of Criminal Appeals, is that it, respectfully, the opinion essentially, it doesn't really analyze this issue. I mean, it kind of just, it kind of touches on it in passing one time, particularly Rodriguez, that particular case, but it doesn't really analyze this particular issue.
Okay.
And the trial court really didn't do an in-depth job of analyzing this either, particularly as to whether the Fourth Amendment would apply relative to whether Officer Forrest or Officer Barber was acting in concert with the government in general.
Gotcha.
Is suppression or exclusion the proper remedy here? I guess assuming that, there's some sort of action that would constitute government action. I mean, what's the sort that I think the state argues that there has to be a constitutional violation to warrant the remedy of suppression. Are they right about that? And if not, then what other, I guess, are they right about that? If so, what's the constitutional violation? If they're not right about that, then what's the other source of authority for suppressing the evidence?
I would submit that there most certainly is a constitutional violation, probably, arguably two, that would trigger.
Do you agree that a constitutional violation is necessary?
I do know that there is some case law that exists that says that a technical statutory violation in and of itself is not enough to trigger Fourth Amendment exclusionary rule action. But in this case, the only thing that we're talking about Fourth Amendment, the touchstone of it being reasonable. The only thing that could possibly make this seizure and subsequent search reasonable is if Officer Barber followed what he was obligated to follow statutorily, which is the private arrest statute. Did he follow that or did he not?
The Supreme Court the U.S. Supreme Court has said that the fact that a law enforcement officer violated a state statute, something like this that kind of limits the authority of the officer is not tantamount to a Fourth Amendment violation. Those are different inquiries. So even if the officer here was exceeding his jurisdiction pursuant to state law, that doesn't necessarily mean that there was a Fourth Amendment violation.
I disagree, Your Honor, because without the statute, he has literally zero authority to pull this man over whatsoever. He has zero authority. He can't do it. And that would certainly not be reasonable under the Fourth Amendment if he's acting in concert with other government officials involved in this situation and he pulls someone over for literally no reason and no authority to do that whatsoever. And then,
but the Fourth Amendment doesn't require that states limit the jurisdiction of an officer to a particular city, does it?
Well,
I mean, that's a statutory limit of state law. That has nothing to do with the Fourth Amendment.
But even assuming for the sake of argument that particular statutory violation doesn't warrant Fourth Amendment relief, I disagree with that respectfully. But even if that is true, there was another constitutional violation relative to Rodriguez because he's effectuating an arrest for the offense of speeding. And we know from the get-go that he literally never intended to effectuate that arrest from before he even effectuated it. And so from the word go, the mission of the traffic stop was dead on arrival.
What in the text of the citizen's arrest statute precludes a private citizen from making a pretextual stop?
Well, Your Honor, there is no provision for a private citizen to do it or not to do it. There's nothing
So
that says.
the citizen's arrest statute doesn't speak to that
It
one way
just
or the other.
says if a public offense is committed within that private citizen's observance, then they can initiate the private arrest.
But it doesn't say that the citizen has to initiate the arrest for the purpose of stopping that public offense or anything along those lines.
It does not say that, but it does not say that they can do that. And I would submit from just a general standpoint, and it's referenced in my brief, that private citizens should not be in the business of conducting police work. Private citizens are not police officers. I'm not a police officer. I should not be in the business of conducting police work. I'm not trained for it. I'm not aware of the protocols. I'm aware of it more than probably most people, but I'm still not a sworn police officer. They should not be in the business of conducting pretextual stops.
And I take your point on that, and I think that explains, why there are certain things that a private citizen has to do. They have to quickly turn over the individual arrested, to a magistrate or to an officer. But when we're talking about a law enforcement officer who is trained and who has, who is a law enforcement officer who happens to be outside of his or her jurisdiction and is making an arrest pursuant to the citizen's arrest statute, I mean, does it make sense to kind of prevent that law enforcement officer from using the skills and training that he or she has as part of that?
Well, I think the problem that we run into there is we're not, you'd have to hold that way, you would have to look at this case in a vacuum. We're not just talking about the fact that the private citizen here happens to also be a sworn police officer. We're also looking at the fact that if the court were to hold, as the state apparently wants the court to hold, that a private citizen can conduct a pretextual stop for some minor traffic infraction and then go through whatever sort of investigatory steps that they want to take.
Well,
That's the problem. We're opening up the door.
And nothing would preclude the legislature from enacting a statute, would it, that would have almost a hybrid situation where to say, here's where we're saying what a police officer can do, here's what we're saying what a private citizen can do. Let's say what a police officer who's outside his jurisdiction can do, but we don't have that here, correct?
Well, implicitly we do. I mean, they have said that a private citizen, a police officer becomes a private citizen 1 mile outside of his or her jurisdiction. They become a private citizen.
Right, but my point is the legislature, if they wanted to, could authorize more actions by the law enforcement officer acting outside his jurisdiction than that of a private citizen, but they haven't done so.
I suppose they have, but they have not done that, and we're not operating under that particular hypothetical.
So, one of the policy reasons that's given for, allowing an officer to kind of act is, let's get drunk drivers off the road. I mean, there are safety reasons to allow this, but I guess, is it your position that, if let's say an officer is just off duty and is driving to a neighboring county and, notices a driver weaving on the road that presents a safety risk, is it your position that that officer who's in a marked car, has just gotten off duty, cannot turn on his or her blue lights and pull over that drunk driver acting pursuant to the citizen's arrest statute? And if they can't turn on their blue lights and pull that person over, then how are they supposed to prevent that drunk driver from inflicting harm on others?
Well, first, the legislature has spoken on this, and they have not authorized that police officer to turn on his or her blue lights, number one. Number two, if someone who's an off-duty officer, this is Davidson County, let's say they're next door in Williamson County, they see someone they believe is impaired, they can pick up the phone just like I can and make a report to 911 and say, hey, I'm following somebody who's swerving all over the road or whatever they're doing. They're on such and such road. I need somebody dispatched out here because I don't have the authority to turn on my blue lights, but the Williamson County Sheriff's Department or Franklin City Police, whoever it may be, they do.
And that's how it's handled now with private citizens. You see somebody weaving, you call 911, report location, follow them, do all the details. You don't pull out a blue light out of the floorboard and stick it on your dash and pull them over.
Right.
Right? I mean,
That's correct. And the private citizen, to the extent it's safe, I suppose, could continue following from a distance to make sure that while they're on the phone with dispatch, the law enforcement is keeping abreast of the location of this person. Going back to the suppression issue, I would submit to the court that it is absolutely the remedy that should be exercised in this situation. This is not a situation where something like a good faith exception should be basically created by the court to absolve law enforcement in this situation, or a private citizen as it may be with Officer Barber, of constitutional violations. This was not a good faith mistake.
has anybody argued, has the state argued good faith?
I know that the state has referenced good faith exceptions within its brief, such as technical exceptions to search warrants, believing in good faith, and you act upon the good faith, and then it turns out not to be that sort of thing. This is not that. This is a situation where Officer Barber intentionally, for 15 to 20 miles, followed this man to well outside of his jurisdiction.
And knew that he was outside.
And he very much knew that he was outside of his jurisdiction. It was an intentional act. He knew that he had no intent whatsoever of following any of those statutes, 47-113, 55-10-207, 47-118. He wasn't going to follow any of them. He wasn't even going to issue him a warning citation. He ultimately did. It wouldn't have mattered, because he knew from the get-go that he wasn't going to follow his statutorily mandated obligations. He was going to intentionally keep this man here for however long it took Trooper Kilpatrick to arrive. Turns out that was 6 or 7 minutes. Unfortunately for the state, that was 6 or 7 minutes too long under Rodriguez. I would ask the court to reverse the opinion of the Court of Criminal Appeals, reverse, vacate, and dismiss Mr. Forrest's convictions. To the extent I have my 5 minutes left, I'm not sure I would like to reserve that.
Okay.
Thank you.
May it please the court. Austin Watkins appearing on behalf of the state of Tennessee. In this case, the defendant was permissibly stopped for speeding under the private arrest statute, and he was subsequently detained.
Let's talk about that for a second. Okay.
Yes, Your Honor.
What provision of the private arrest statute was this a lawful stop? Is it 1, 2, or 3?
It was under a public offense committed in the officer's presence, or the arresting person's presence.
Okay, so speeding.
Yes, sir.
Okay, but so he had no intention of doing anything with regard to the speeding. But he still, as a private citizen, has the right to make that stop with his blue lights.
He has the right to make an arrest. I will acknowledge that the blue light statute is a little unclear. What the blue light statute restricts is the ability of someone, including law enforcement officers, to use their blue lights unless it's in furtherance of their official duties. So I think
how is it official duties if he's a private citizen?
He's still acting as a police officer at the behest of his superiors. He is upholding the law. So
the fact that he's 20 miles outside his jurisdiction, he can do anything and everything a police officer can do.
No, Your Honor. I mean, he has to act within the scope for arresting in constraint with the private arrest statute. So, and a big thing that's going to be noticeably absent that this statute would not authorize an officer outside his jurisdiction to do is make a Terry stop. There's no statutory basis for a police officer to investigate a suspected offense. It only authorizes an arrest for an offense that was committed in that officer's presence or in a private citizen's presence.
But you can't arrest someone for speeding. You have to cite them in lieu of arrest and let them go.
Sure, but you can make the arrest you need to effectuate the citation. I mean, there's a difference. We cite the Walker case there in a great footnote that clearly explains.
So are you conflating arrest and stop?
Yes, I would say under the statute, an arrest is synonymous with stopping. Like, I am stopping you for the purpose of arresting your liberty. You have broken the law. This would be whoever the private arrestor is making a stop that would be an arrest, but it is not a custodial arrest in the sense that in construction with the cite and release statutes is not a custodial arrest. This is not a full-blown booking, a taking to the magistrate. You are processed through jail and then kind of held until you've got a preliminary cause or a magistrate makes a determination about whether this offense was committed.
Let me just cut to the chase. How did he legally keep this defendant there on site until Trooper Kilpatrick showed up?
Your Honor, because he was authorized under this private arrest statute to arrest for a public offense, such as speeding, the 6 minutes it took for him to ask for license, registration, and proof of insurance was part of him effectuating that private arrest. If you look at what the statute requires for a citation, it is a lot of information.
Could a private person have called in and checked the license and registration of the vehicle?
Maybe. I don't know. If you call
Maybe.
911 and...
Where's the authority? Where is any authority for a private citizen to do that?
Oh, there is no explicit authority, Your Honor.
Okay.
There is not.
Then you said maybe. Where's the maybe?
No, I mean, literally, if someone said, I have made a private arrest, I am calling because I want to know if this person is dangerous or not. Do I need to worry about my safety as I try to comply with the other part of the private arrest statute by taking them as quickly as possible to a magistrate or to an officer? What do I need to be worried about? I don't know what they would say. I mean,
You don't think that the proper thing to do would be to contact an officer with authority and get them to make the check?
Well, I mean, I think that would be fine. My point is I think if we're trying to work with this, what would it look like for a private person to arrest someone for speeding?
Well, I mean, what we are looking at in this case is, what does it look like for a private citizen to stop somebody with no intent to actually arrest them? Really, the only thing that he had in mind was to seize him, stop him. Everything else, you're acting like asking for his license, all that kind of stuff, because it's the usual pattern that a police officer would engage in. But for a private citizen who has no intent to do, let's say he has authority to stop him, to seize him, but he has no intent to do anything more. So how does all the rest of what he did amount to anything other than just fluff, just stretching it out?
And this follows up on the question again. The state acknowledges there is no explicit authority for those things, for asking for a driver's license, for requesting proof of insurance or registration. I can't point you to a statute that says that.
For arranging for a drug dog to be on the way before a stop's made.
Well, that's correct. There's no specific authorization for that, but what is authorized is an arrest. And so if this officer, for example, under a literal reading of the private arrest statute, had, we'll say blue lights, had used blue lights, but had somehow gotten this individual to stop then waited.
Well, how did he even have the authority to use a blue light to stop him? Didn't he violate the law by even making that stop?
Well, the state can concede that he did. And the reason
he violated the law by making the stop?
He
using
did.
the blue light?
The state can concede that he did. My point is it would depend on whether this was considered to be in his official duties. If you assume that he was not and said he's not acting as a police officer, we're going to treat him as a private citizen, then that would violate the letter of the blue light statute. We cited the Epps case as a Court of Criminal Appeals case that talked about a citizen using the blue lights to effectuate an arrest. Now, what the Court of Criminal Appeals said was, both things can be true. Someone was entitled to make an arrest, but made that arrest in an unlawful manner. That doesn't get you suppression. It doesn't make the arrest unlawful. It means that the person who used blue lights is subject to prosecution.
But doesn't it get you to suppression if he is doing all of that as an agent of law enforcement agency that did have jurisdiction? If he had, I'm not sure what the record will show. Well, the record will show that Trooper Kilpatrick was basically on notice beforehand. I'm going to follow this guy and I'm going to stop him if he does it, goes 1 inch over the line or something like that. So be at the ready. If the entire thing is as the agent of a law enforcement agency with jurisdiction, how does that not get you to suppression?
Because it is not the same as a constitutional violation. But in Virginia versus Moore, the Supreme Court of the United States, and that's a cite and release case, where police officers in violation of state law subjected someone to a custodial arrest. Not just they held them a long time, but arrested them, got consent to search a motel room during their holding them, and all of these other things. And what the Supreme Court of the United States in that case, it's cited in our brief, is that the Constitution views that as a permissible arrest because it was based on probable cause. And the fact that those officers were not acting with statutory authority, they exceeded the cite and release statute for that arrest, it was a traffic offense, they said that in and of itself is not enough for a constitutional violation. It is not enough for suppression. This court, we've acknowledged, can apply suppression here if it thinks it's warranted. And this court has done that. When it thinks there's a statutory or a procedural rule that's been violated that implicates the Constitution, it's of a constitutional magnitude. We cited the Frazier case where essentially this court said if a magistrate doesn't have jurisdiction to issue a search warrant, then that is the equivalent of you acting without a search warrant, and that is a constitutional magnitude. Then this court, applied the exclusionary rule. So the state understands that, but in this case, and the state agrees that this officer was a state actor, and not because he was acting at the behest of a trooper with jurisdiction. He was outside of his jurisdiction, but he was acting with the intent to uphold the law for the purpose of enforcing the law, and that's all that the Constitution requires. So that triggers all of these constitutional protections. And in this case, what the state's position, maybe this is a clean way for me to state this for you all, is that when you view an officer outside his jurisdiction, this legal fiction that he somehow becomes automatically a private citizen, the court doesn't need to embrace that. What it can do is say is his authority is constrained to the extent that he can only arrest and act within what would be an arrestable kind of offense for the private arrest statute, but he still is a police officer.
Yeah.
But doesn't that go to the question I asked other counsel that the legislature could certainly enact a statute that allowed him to do that, but there is no such statute here. It's either or. You're either a law enforcement officer or you're a private citizen.
Well, Your Honor, I'll push back on that a little bit, and here's why. The White versus Revco case that we've cited, not like we didn't brief it full out, but we pointed to, that is a case about off-duty police officers. And what that case says is that an officer who can even be on the clock for a private employer can still act with the panoply of official police power if he chooses to act in his police capacity.
Within his own jurisdiction.
That is true. But I mean,
that's a big
difference.
Yeah.
No, it is. But I mean, the state has if these officers are trained to act statewide, they're post accreditation.
I don't disagree with you, but that's an argument for the legislature. That's not for us.
That is true. I mean, this statute was written in 1858. We didn't have blue lights. We didn't have cars. We didn't have cell phones.
Also, whatever holding that we issue on this case is going to apply to every private citizen out there.
That's true.
Every police wannabe out there who, is going to be looking at what a private citizen can do, what we say a private citizen can do, and will be able to use it. So we can't say this is only going to be used by police officers who have a lot of training and they know what they're doing, because that's not accurate.
Well, and let me follow up on that, because I guess what I understood the argument you made a moment ago to be is that in allowing officers to use their official authority when making an arrest pursuant to the citizen's arrest statute, I mean, they would be treated differently than a private citizen making an arrest pursuant to the citizen's arrest statute. Am I right about that? I mean, is it necessarily true, I guess getting to Justice Kirby's question, that, if this is allowed, if an officer is allowed to do this acting pursuant to a citizen's arrest statute, that any private citizen could do exactly the same thing, could pull someone, use blue lights, pull someone over, check registration, check for warrants?
No, I don't think so. I mean, this court could say if you are a police officer acting within the course of your duties,
Based on what language in the statute? We're interpreting a statute.
I understand that. There is no statutory language. I'm not trying to
So we
act
can
like
just make it up? We can make up an exclusion for
Sure, I think this court can look at an old statute and reasonably go, if it authorizes, if we have said what we said in Johnson, what this court said in Johnson, is that an officer outside his jurisdiction, and in that case was in a marked car and used his official authority in a different county to stop someone until that county's officers got there. This court said, we think that is the arrest itself, the stopping, is consistent with what the authority is in the private arrest statute. This court could look at that and go, well, here's what we think we have to do, because it is allow an officer to effectuate an arrest in a way an officer would. He can call for backup. He can use the databases that he has, where the state's not asking for a lot more authority here. I mean, the arrest provision is there that a private person in your neighborhood, if you saw someone who was breaking a traffic violation, the legislature has said that as a public offense, a private person can make an arrest for that.
Is that a good idea? For policy reasons, are we asking to go back to the 1908 case, persons marauding into other counties and causing mayhem?
Right, Your Honor. I wouldn't want to say what is good public policy, but that is a legislative question, and this court has pointed out multiple times that this arrest authority is very broad and almost synonymous for private citizens and for officers. And so if we're going to allow private citizens to stop someone for speeding, why not allow the officer to use his resources to make the stop for speeding?
And it sounds like a great argument to the legislature to me. And in fact, look at what happened in, I don't remember the name of the case, but the case in which we determined that a judge did not have authority to sign a search warrant outside of his jurisdiction.
Right.
Legislature turned around, and rightfully so, and then it says you can sign it anywhere statewide. You could do the same thing with a law enforcement officer, but it hasn't.
That's correct, Your Honor. That's correct.
What's the point of TCA 654-301, which provides that an officer, that their authority extends 1 mile from the lawful corporate limits? Why even have that statute if they've got statewide authority?
There can be administrative reasons for why you want it to be clear who's in control of the officers in which jurisdiction, who is paying for their...
But if we agree with you here, basically we're saying Knox County officers, when you're off duty, you can all pile in a car or caravan over to Memphis. I hear they've got problems there, and just start arresting people.
Well,
Or stopping them with blue lights and seeing what's going on, and you might look up and be able to arrest someone. I mean, is that what we want to do here?
well, Your Honor, the state doesn't want to incentivize, this activity. But what we're focusing on is whether this gets him to suppression. And so to specifically answer your question about, someone from Knoxville going down to Memphis and wanting to enforce the law, there's no geographic restriction on private persons under the private arrest statute.
Yeah,
so
but-
that can happen. But
Okay, but his authority under the citizen's arrest statute extended under these facts at most to stopping. That's it, because he didn't intend to do anything further. He didn't intend to issue a citation. He didn't intend to actually arrest him. Everything else that he did was in concert. I'm going to assume that the facts show that that he had been in contact with Trooper Kilpatrick beforehand, be on standby. So everything else is drawing it out in order to give Trooper Kilpatrick time to get there. If he's doing all of that with no authority as a private citizen, but acting in concert with law enforcement, how does that not get you to suppression?
Well, because it is a violation, because the Constitution says an agent of the state can make an arrest for probable cause. That means it's constitutional. So, I mean,
An arrest for?
for speeding. And if he was
Okay,
normal,
that's, my point was, once he stopped him, that the rest of the remaining 6 minutes of the 7-minute period are not for that purpose at all.
well, but for Fourth Amendment purposes, for suppression purposes, he's still acting as an agent of the state and is doing the traffic investigation that he would have been able to do in his jurisdiction. I mean, so the statutory violation
Investigation of?
of speeding, and that's what Rodriguez acknowledges this, that if you're pulled over for speeding, an officer gets a reasonable amount of time to ask for a driver's license, to check criminal history.
That's an officer.
Right, but
I mean, all a private citizen knows is, I saw this guy on the highway, he was driving too fast.
I understand that, Your Honor. For suppression purposes, though, he gets to act as if he's an officer. I mean, just because he's exceeded his jurisdiction, that doesn't create a Fourth Amendment problem as long as he has probable cause of an offense. Okay. And so that is where the suppression issue gets kind of, for us, is important, because if this court finds, and it sounds like is willing to find, that he needed a statutory justification for every question he asked, well, the state has kind of pointed out, well, if he strictly followed the statute, it says take him to a magistrate or to a officer. So if he had stopped them for speeding, walked up and said, I've stopped you as a private citizen for speeding, there's a trooper on the way, hold tight for me, and waited 6 minutes till Trooper Kilpatrick got there, and that this is in the cite and release statute in the same, part as the private arrest statute that talks about cite and release, the general cite and release statute, it contemplates an officer receiving someone who has been arrested by a private person. So if the officer
It doesn't contemplate the use of a drug dog to sniff out drugs at that point, though.
No, the statute doesn't, but when the officer arrives, the state trooper who has statewide jurisdiction, it contemplates him using his dog to search for drugs.
Particularly when he's been called before the stop takes place.
Well, and I want to follow up on that because I have really the same question for you that Justice Bivens had for defendants counsel, and that is, what does the record show about how the trooper got there?
The name of the person who called for the trooper is in the record. That person is not clearly identified. It was not this officer. It was either part of the surveillance team or a dispatcher. So someone else called for this trooper ahead of time, and he testifies in suppression hearing and at trial that he's on his way with the expectation that there will be a stop. Everyone acknowledges it was pretextual. We had been doing this surveillance. We wanted to find a traffic stop on him and then hold him and do the dog sniff.
But Mr. Barber was fully aware before he made the stop that the trooper was going to come with the drug
He testified that he knew the trooper was coming, and then you can hear it on the dash cam video right after he kind of returns to his car with the license. So when someone says THP will be there in 5.
And that the trooper is not coming to arrest him for speeding. That is not the troop. That is not why the trooper is not coming to receive him under the citizen's arrest statute for the offense that the private citizen witnessed.
That is correct, Your Honor. I mean, no one had called him and said, there's a traffic stop, come deal with the traffic citation. I mean, I acknowledge that. But for purposes of him getting to suppression, if we can string these things together to show that this was an appropriate, reasonable means of him effectuating the private arrest by simply asking for a license, outstanding warrants, and registration, and then a trooper shows up within 6 minutes who has jurisdiction, at that point the detention is going to be constitutional and lawful based on the trooper's jurisdiction. I mean, it's a very quick amount of time here. So, if he had just waited and let the trooper pull him over, it would definitely be a different case here.
It sure would.
I acknowledge that. I mean, there are a lot of different moving pieces in how this could work, but I do think there's a lot of cases from the Court of Criminal Appeals that show when there is an officer who's outside his jurisdiction, whether it's intentionally or you just happen upon the drunk driver, that they need some ability to be able to hold someone for an offense that is arrestable under the private arrest statute. Like the legislature has said, we are okay with someone, whether it's an officer or a neighbor, arresting you for a traffic offense. And so we're talking now about, well, what's his statutory authority to how he does that arrest? And so the state's position is for him to sit here for 5 or 6 minutes and go, I want to have your license and I'm going to hold you, and knowing an officer with jurisdiction is coming, and then we'll decide how we process it out, whether we want to write a ticket for the speeding offense and do the dog sniff, or we just want to do the dog sniff.
But he's already said he's not going to do the ticket.
Well, Your Honor, he said he didn't have an intention. And we cited the Burleson case as I believe it's an 8th or a 10th Circuit federal case that says constitutionally, the officer's intent at the get-go doesn't matter. It doesn't affect the reasonableness of the period in which someone is held in a traffic stop because the officer's intent can change. Part of why you do this traffic investigation, following up on license and registration and proof of insurance, is to determine whether maybe this person does need a speeding ticket. Maybe if I let them off with a warning like I intended, they're not going to take that seriously. They may try to speed away from me. Or maybe I do a background check and find out this is...
And that's what a valid law enforcement officer can do, but not what a private citizen can do.
We require police officers to comply with the law if they're going to enforce the law. I mean,
yes,
this guy exceeded his authority. He violated the blue light statute so he could make a stop. It bothers me that a law enforcement officer can decide just to ignore the law in order to enforce the law. We should hold police officers to higher standards than that.
I understand, Your Honor. I understand the irony of the state's not asking this court to condone acting beyond a statute. But
Wouldn't we be doing that if we allowed this?
no, Your Honor, and I think the reason is this. Whether the officer is acting unlawfully, unless it somehow creates a constitutional problem, is a separate issue of whether suppression is achieved. So this officer can be acting unlawfully, and this person can have violated the law and still deserve to be prosecuted with the evidence obtained, and both things can be true. This court can condone unlawful, police conduct that literally exceeded its statutory authority, and it has done that before.
So are you now conceding that it was an illegal stop, and the question is the remedy?
No, Your Honor. What I'm acknowledging is this: if this court were to find that asking these questions violated the statute, that would be an illegality. That's simply the semantics I'm trying to acknowledge. I understand this is kind of an interesting case.
Justice Bivens was digging a hole and just letting you fall in.
I understand
Is there
that.
any other recourse against an officer? So let's say suppression of the evidence is not the remedy. Is there any other recourse if we have a violation by the officer of the statute limiting the officer's jurisdiction? It's not a constitutional violation, so suppression's not proper. I mean, what other mechanism might there be to kind of enforce that statutory limitation on the officer's jurisdiction?
Right. One example would be McCaslin versus McCord. That's the old roving band of marauders. That's not a criminal case. That is a civil lawsuit case where they kicked in the wrong door looking for an escaping criminal, and they were sued for that. So tort liability, criminal liability for using the blue lights when you're not authorized to do so is a crime.
But he's not been prosecuted for that, has he?
He hasn't, but that doesn't mean that this defendant should get to escape for carrying cocaine and marijuana. I mean, both things can be true. The officer can be prosecuted for breaking the law, but so can the defendant.
But the defendant has no control over whether the officer is prosecuted for using his blue light when he was not authorized to do it, does he?
That is true. He could turn around, and if that would constitute a tort, he can sue him for that. And then so if this officer is outside his jurisdiction and is acting as a private person that's not within his official duties, maybe he loses his immunity. I mean, there is a way for this defendant to try to get recourse if there's a problem with a statute, if this officer doesn't get to do those normal things. But again, the defendant has to show that is a constitutional violation as to him, such that the state can't use the evidence found against him. And the reason I think it is important to point out is that, he was subject to arrest for speeding. And the state trooper has statewide jurisdiction. We're talking a few minutes where it's not if he would not have otherwise have gotten off scot-free if this officer had not have stopped him. There was a whole task force who thought they had reasonable suspicion to stop him immediately, and then were waiting for a traffic stop and working in concert with the highway patrol. And so the state is trying to tease out that this court can find that the police officer violated a statute, that acted in a manner in which he should not have done. But it still can find that suppression is not appropriate in this case.
I want to go back for a minute to the pretextual nature of the stop.
Okay.
Certainly, a police officer acting within his jurisdiction can make a pretextual stop. That's well-settled law. But in the private citizen context, and let's set the table here, because clearly the legislature has not adopted a statute that allows a private citizen to make a pretextual stop, correct?
Yes, sir. Yes, sir.
So it would be up to this court to decide, as a matter of public policy, along with it, as to whether a pretextual stop is appropriate by a private citizen, correct?
Correct.
All right. What good public policy would countenance us to say a private citizen, any private citizen, can make a pretextual stop?
Upholding the law. If a private person is making a private arrest, say it's my neighbor and I just really dislike my neighbor. So
you are taking the position that every private citizen in the state of Tennessee should have the right to make a pretextual stop?
The private arrest statute doesn't care. I mean,
I understand that, but I said the statute's silent on that. My question to you is, are you representing to us that it's good public policy in the state of Tennessee for this court to allow pretextual stops by any and all citizens of the state?
I want you to imagine yourself going back to General Slatery and explaining.
Well, that's why I paused before I answered. And so I would love to demur if you'd let me do that, Your Honor. Because it's definitely above my pay grade.
My point's made, never mind.
No, it is made very well, Your
And
Honor.
if you say yes, that's really good news to all the sovereign citizens in the state. And in the country, they're going to come here and
That's
do
right.
a lot of stops. I may do a few on my way back to Knoxville tonight. Well, I'm just thinking, there's going to be a few cars I'm going to check out.
I understand. Take a little bit of levity here. I mean, there's a Mayberry joke in here somewhere.
Yeah, that's right, exactly.
I'm aware of that.
Gomer's
really
Gomer, right?
That's correct. So, it is an interesting situation, and I think this statute is very broad. We have to start with that. There are not a lot of details on how these arrests can be made, and this officer, I think, was doing a very reasonable thing in saying, it says I can arrest him for speeding, and so I'm going to stop him and assume that if I do that in a non-invasive way until this guy gets here soon and who has jurisdiction, that's enough. That if I literally say there was no drug investigation, this would be the same way I would stop him for speeding and just giving him the speeding citation. I mean, I would hold him for 5 minutes. This was actually a very quick traffic investigation. If you look at Rodriguez and several others that we've cited, yes, this defendant would have been stopped, and I don't want to minimize him being seized, but the way the officer handled this, he was not dragging this case out for a very long time.
Didn't the end of the traffic stop, the end of it occurred when the trooper showed up? If the trooper showed up 20 minutes later, it might have been a 20-minute stop, correct?
Oh, that's correct, Your Honor, and I mean, I have no problem. The Constitution protects that. Rodriguez says you can't just sit there and hold someone indefinitely. And this case.
Go ahead. I'm sorry. Go ahead.
No, this case kind of below was briefed and originated as a Rodriguez case. I mean, was the duration reasonable? Everyone kind of assumed what he was doing and how he was doing it was pretty much not necessarily specifically authorized, but was consistent with this court's decision in Johnson and how an officer outside his jurisdiction would effectuate a private arrest. The question was he wasting too much time in doing that? And this court doesn't need to be concerned with that because Rodriguez covers it. The last thing I will quickly say, since we've been talking about being concerned with private arrests, is in all of the research I could do, other than security guards, I could find almost no cases that just in passing talked about the origination of that case with an actual arrest from a private person. And I say that just to say there is no evidence of an epidemic of private arrest by private persons, acting kind of ultra vires, so to speak.
That's because most citizens of this state do not know about this statute.
I hope I haven't drawn too much attention to it. Thank you, Your Honors.
Thank you.
Thank you.
Subject to any questions the court may have for me, two things. There was a question asked, how could Officer Barber have been authorized to keep the defendant there until Trooper Kilpatrick arrived? The short answer is he was not authorized to do that. And he was there for at least 6 minutes. The critical question under Rodriguez is not whether the dog sniff occurred before or after the officer issued a ticket, which of course Officer Barber never even had an intention of doing, but whether conducting the sniff adds more time to the stop. That is the question. And the answer to that question must be that it did, because of the fact that he never intended to follow his statutory obligation to do something. Whatever that is, whether that's to arrest him, to take him to the nearest magistrate or officer who had the authority to issue him a citation and cut him loose, he had to do something, and he intentionally did nothing. And therefore, under the precedent of Rodriguez, he had to have added 6 or 7 minutes to the duration of the stop as a ruse to wait for Trooper Kilpatrick to get there. That's part of what makes this constitutionally unacceptable, is that he was violating this man's constitutional rights as working complicit with other government officials to keep him there longer than was necessary to effectuate the mission of the stop. The mission of the stop was speeding, and he never intended to effectuate the mission of the stop to begin with, and it was dead on arrival.
Are you aware of any cases in which, a delay of about the same amount of time, say 5 or 6 minutes, was held to have unconstitutionally prolonged the stop?
I am aware of cases that hold that a law enforcement officer in particular who's investigating a minor traffic infraction, the stop lasts 6 minutes, 7 minutes, 9 minutes. It varies. I am aware of the idea that while that person is taking the investigatory steps like driver's license, registration, insurance, doing all of that, talking to dispatch, and then a dog sniff arrives while all that's going on, there's plenty of cases that hold that that's acceptable. That wasn't taking place here. Because as the state admits on page 40 of its brief, in passing, Forrest posits that an ordinary citizen would not be able to conduct a traffic investigation during a private arrest. That would include driver's license, insurance, registration, call-in dispatch, all the things I can't do as a private citizen.
But a private citizen may have to wait 6 or 7 minutes for, I mean, would 6 or 7 minutes be a reasonable amount of time for a private citizen to get the individual to a magistrate or to an officer?
Not necessarily if that was the actual intent of what was going on here. That was not. The state admits that a private citizen doesn't have the ability to do a traffic investigation. And from the get-go, and I hope the
So it's not
citation-
necessarily the time, in your view, it's not necessarily the amount of time that passed, it was what was occurring during that time? Is that accurate?
Well, I suppose if you extended the hypothetical out to its limits, both could be true. The time and exactly
Well, in
what
this
was-
case, I'm just talking about in this case.
I mean, I think if it were undisputed that Trooper Kilpatrick was coming to the scene for the purpose of taking possession of the defendant's person for the purpose of issuing him a citation or bringing him to a magistrate, I think if that were the facts, this case might turn out differently. But it's undisputed that that's not what he was doing. I hope my citation in the brief is correct on suppression hearing, page 36 and page 49, that he was en route, at least as far as I can glean, from the time that Officer Barber and Mr. Forrest left the apartment complex. And he was en route with the drug dog for that purpose. I also want to point out something that Justice Kirby mentioned relative to police wannabes, was the phrase. And maybe I'm naive, but on January the 5th of 2021, I had never thought that rogue vigilante citizens would take over our United States Capitol building. I never would have thought that could have happened. And the very next day it did. And the idea that we should give all of those sorts of people who obviously exist a carte blanche green light to go around doing what happened here to Mr. Forrest, just looking for stuff. Wherever each of the court's members live, getting pulled over by some rogue person, just looking for a reason to conduct a search or whatever they're doing, that's not sound public policy. That's not going to be found anywhere in a statute. That would have to be created by this court, and I would respectfully submit that that is not good public policy.
Thank you, Mr. White. Time's up.
So, thank you.
You okay to go home? All right, let's call the next case, please.
State of Tennessee versus Lynn Frank Bristol.